As a trial lawyer, how can you make sure that your hard-won verdict remains intact? Or, if necessary, how can you make sure that the appellate court is going to actually hear your case? This video will answer your questions. Welcome to another edition of Florida Appeals Journal. I'm Jennifer Carroll, and hope everybody is hanging in there like the rest of us. Take it one day at a time, of course. This week, I decided to do a refresher on the top 10 landmines in civil litigation. I think we can all use a refresher on this matter. And there are so many landmines, of course, for anybody who does litigation. But in my experience, I've come up with 10 that are pretty commonplace. Few people really realize it. And if you aren't careful, you can really mess your case up. So we don't want that. So I'm going to highlight the key areas today. And you can look, I believe, on the journal, on the website. We'll have all the cases that support each of the 10 areas I'm going to be talking about with you today, and some of the updated cases as well. So landmine number one, this is a very common issue: motions for rehearing or motions for reconsideration and non-final orders. And basically, when you have a motion, whether you call it a rehearing or reconsideration, against an order that is not final, that will not toll the time for taking an appeal. So people always misname it, and you want to be careful, but you want to look at the substance too of what's going on. So a motion for rehearing is directed toward a final order. You file that, then that tolls the time for taking the appeal. So if it's a proper and timely motion for rehearing, that will stop the clock, and you'll have 30 days from the date of the decision on that motion for rehearing. And that's what's considered an authorized motion for rehearing, sufficient to toll the time. If you have a non-final order, which means there are more things to be done to the case, basically, that's a simple way to put it. You can move for reconsideration, but realize you're not entitled to just set a hearing on that. You still have to wait for the trial court to set a hearing, and trial court may not set a hearing. Trial court has discretion to determine if they should reconsider it. The other thing about these motions for reconsideration on a non-final order, a trial judge can change his or her mind at any time with a non-final. So you can later revisit that non-final order and get it changed if circumstances have changed, if it's justified. So it's a fluid, relative fluid principle. So keep that in mind, though. No matter what the title, whatever you call it, if it's a final order, and if you move for rehearing or reconsideration of a final, it's going to toll the time for taking the appeal. All right. Now, number two, landmine number two. I'm going to call it jury selection. And you need to know, in order to preserve your right to challenge errors in the manners that's used to select the jury, you have to object at the trial to the jury as it's finally composed. Otherwise, you're going to waive your right to complain on appeal. Now, while I'm talking about juries, I'm going to combine them all together. So you've got also jury instructions, and you're going to look at Florida Rule of Civil Procedure 1.470B. That mandates that no party may claim the giving of a jury instruction as an error unless that party objects at the charge conference. Otherwise, the failure to give any jury instruction unless the party has requested the same. So like other objections, specific grounds must be stated. And also, when you're submitting your jury instructions, you do want to do them in writing as well. So you are going to have to object at the charge conference, and just be very specific and specifically request the jury instruction that you want. Then, while we're on the jury issues. Let's talk about the jury verdict. That's the next landmine. And that's important, of course. We all know that. To preserve for appellate purposes any error created by the receipt of an internally inconsistent verdict, an objection has to be made before the jury is actually discharged, and inadequate verdicts are challenged by a motion for a new trial. So it's really important in how you draft your verdict form, depending on the issues in the case, of course. But you have to try to just step back and always use common sense. Is the ruling on one of the issues, if I don't word it just right, then that can be inconsistent. You can create inconsistency by the jury, and you don't want that. Now, a major landmine in civil litigation concerns the two-issue rule. That rule provides where there is no proper objection to the use of a general verdict, reversal is improper when no error is found as to one of two issues submitted to the jury on the basis that the appellant is unable to establish that he has been prejudiced. Okay, so what's a simpler way to say this? And I like this in the Chua case. This was a 2003 case, 846 Southern 2nd 1179, but we'll include these. But I'm going to quote this. I really like their explanation here, and this is by the 4th District. In that case, the two-issue rule barred the surgeon's appeal of the admission of surprise testimony by the patient's expert witness as to whether the surgeon was negligent in performing eye surgery on the patient. Where the jury rendered a general verdict on the patient's multiple theories of liability that included different claims of negligence and including a lack of informed consent. So the court held that the surgeon was unable to show error in the jury's general determination of liability in the face of the patient's three alternative theories, and the jury's general verdict did not specify which of three theories were found proven by the evidence and the law. So I like that because I think that's a classic example of use of the two-issue rule and the problem with it. So that's a huge landmine. I'm going to include some recent cases in the journal, and you can refer to those. But that's something you want to be very, very careful with when you are working on your verdict form. Now, I believe we're on landmine number 5, which is admission and exclusion of evidence. Definitely a key matter in litigating a case. So, you start with motions in limine, of course, pre-trial, if you need to keep certain evidence out, especially when you're dealing with the jury. If the judge has denied your motion, your pre-trial motion for a motion in limine, and the evidence that was subject to your motion in limine is offered during trial, what do? You still have to object. Just because you file that pre-trial motion in limine doesn't mean that it's preserved forever. That's not how it works. So you still have to make a contemporaneous objection when the evidence is offered in order to preserve it for appellate review. Now, if the judge has, I think is very relevant, very important, and you've just made a general reference to the evidence that during argument to the judge, the appellate court will not consider it. You've got to make what's called a proffer, or with other words, an offer of proof. So you really got to give the trial court an idea of what the substance of that evidence is. So of course, if it's a document, you're going to want to proffer that. If it's testimony, you can, some people will just proffer by putting a witness on the stand, judge will go out, jury goes out, or you do it even at the end, although I think you need to do it as early as possible in the case. And sometimes a judge will stay in a jury trial, but you got to make it known to the judge because it's only fair you're giving the judge a chance to know the details. Here's the evidence specifically, and here's why it's important. So you want to make that proffer, and that will preserve it. And if for some reason you can't put a witness on the stand, you can still give a pretty detailed summary of what that witness is going to testify to. And you may even have a pretrial deposition that you can put in as a proffer. But you've got to do the proffer. And when you are objecting, these days, I think the judges have gotten more specific, more sophisticated on this issue. You want to make your specific legal objections. Be very specific, cite the rules, cite the case, and then you're well on your way, not only to apprising the judge of what your evidentiary issue is, but of course preserving your record for the appeal. Now, and this goes to just general rule on objections, and that's another landmine, because then you have objections of all kinds during trial, of course. But they got to be specific, they got to be timely. So let's say you're in, a 5-day trial, and you can't, on the 3rd or 4th day say, Judge, that ruling you made on the first day of trial, that's not good. No, that's not a contemporaneous, it's not a timely objection. And of course, I'm sure most attorneys know better than that. And again, state the legal grounds, and just think about it. It's only, you do this, the rules exist, for several reasons. And a key reason on this particular rule, it's only fair to apprise the trial judge of the law you're relying upon and what's the basis. And if you don't do that, then the appellate court says, well, we don't really think you're being fair to the trial judge. So you got to give the trial judge an opportunity to rule on your objection and the grounds that you raise. And you need to remember too, you need to get a ruling from the trial judge on your objection in order to carry it forward to the appeal. You'd be surprised how in the heat of the trial and so much going on, a lot of that can get lost. So be very careful with that. Now let's talk about the next landmine, which is directed verdict. To challenge the sufficiency of the evidence to go to the jury, you have to make a motion for directed verdict at the close of the plaintiff's case, and then you renew it at the close of the evidence. And again, just like other objections, evidentiary objections, the motions for directed verdict have to state the specific grounds, and it's only those grounds that are going to be considered on appeal. And then after moving for a directed verdict, then you've got to go and move for judgment in accordance with the motion for directed verdict if you wish to appeal the denial of the DV or the sufficiency of the evidence. The motion for the judgment in accordance with the motion for directed verdict can be joined with the motion for new trial. So all this usually occurs, of course, after the jury verdict, and you usually would join it for new trial motion. Now, a party who fails to move for the directed verdict at the trial waives any right to later request a judgment notwithstanding the verdict. Very important. Next landmine. All right, let's talk about mistrials. I think we're on probably number 8, I think. A party who objects, receives a ruling sustaining an objection, and receives a corrective instruction should still move for a mistrial if he or she believes the instruction does not remedy the problem. That's a critical principle. Let me give you an example of mistrials. They can occur, motions for mistrial can arise for several reasons. You may have a client that goes on the stand, and let's say your client's the plaintiff, and the plaintiff testifies, hey, that defense company only offered me $10,000 at mediation. I can't believe it. My claim is worth $10 million, and you can't do that. That's a bad thing. And that can justify a mistrial, the judge declaring a mistrial. So you've got to go ahead and promptly move for that mistrial. I saw a case, I'm trying to see how recent it was. I liked it. This is, let me see what's this dated, 2013. It's on the 2nd. It's Carvajal v. Penland, 120 Southern 3rd, 6. That's a 2013 case. And I'll probably have to do a separate segment on the journal just on what you can and can't say as a witness or even as an attorney during trial, because it can get you in a lot of trouble. But in this case, you had the party say while she's testifying, quote, I would never be here for any other reason but, because I can't believe they're not going to take care of this and be responsible. I paid my bills. I paid my insurance. It's crazy. And then she continued, I paid more, I had more coverage. And then they dropped me. Then I get dropped by then. Well, you know, everybody had a field day on that. So the judge had to excuse the jury from the courtroom. You had the insurance company move for a mistrial and arguing that a curative instruction wouldn't be enough to repair the harm done. The bell had already been rung against them. And in that case, they even had an order on a motion in limine said, witness, don't say that. So what the judge ended up doing there is just said, well, please disregard that last comment. And that's tough. So every day after that, the defendant kept coming back and actually moving for a mistrial again. And then the error was compounded during the closing argument. Even though the plaintiff's counsel promised the judge, I'm going to make sure nothing more gets said about this, the counsel made several references in closing about the insurance company, quote, not accepting responsibility. So here's an excerpt from the closing argument. And this is the Penland case. So Penland never imagined that she would be in this courtroom. She never imagined that she would be fighting this fight. She purchased uninsured motorist coverage so that if she was hit by someone like the defendant, she would be protected. So at that juncture, the insurance company objected, and of course saying, hey, counsel statements were improper. Objection was overruled, and then our attorney continued, and the insurance counsel, defense counsel continued to object, and then actually even had co-defendants were objecting. So I think the co-defendant requested a curative instruction and moved for a mistrial. The objection was sustained by the trial judge, but the request for an instruction and the motion for mistrial were denied. And so the counsel just really continued with his argument. So I believe in that case, and they did grant the new trial. When it said that independently, cumulatively, the motorist testimony, so we're looking at her testimony in her attorney's closing argument warranted the granting of a new trial. And that's an example of well, you're going to get a new trial, but you also should have gotten the mistrial, but you'll keep asking for that mistrial. You need to really be knowledgeable about the procedure on moving for the mistrial, and we're going to get to actually the next landmine, which is misconduct of counsel, which are these improper arguments. So the court, so that the trial court does have the power and the authority to wait until the jury returns its verdict before ruling on a motion for mistrial. Because a lot of times judges will do that because they're trying to streamline the process and think, well, the jury, rules against them, then it's fine. Why risk, creating an issue that is going to be fought for, a year or so on appeal? So they can do that. And then sometimes it's so egregious too, a judge will just go ahead and grant the mistrial. But a lot of them do like to wait. Now the timeliness of the motion for mistrial is extremely important. And some litigants now will make a tactical decision, right? It's all about strategy, to take their chances with the jury. And if they lose, they think, I'm just going to move for a new trial. But the appellate courts are very watchful of that, okay, very wary. And they've held that failing to move for a mistrial during trial, if it's not made during trial, then the litigant has failed to preserve the error for further review. So if you've got something outrageous happening, whether it's in the testimony, behavior of counsel during trial, then you want to move for a mistrial. And a lot of times you can move for a curative instruction, but depending on what the deed was, what the action was, that may not be enough. And you're going to want to argue that to the trial judge also, that the bell is rung. My client is highly prejudiced and there's no returning from that. Now, the next landmine, as I said, is the misconduct of counsel. This is another thing. You've got to be very watchful on procedure. The challenging the attorney misconduct requires very close attention to the specific procedures. So when a party objects to attorney misconduct during the trial, including improper argument, and the objection is sustained, then that party must also timely move for a mistrial or request a curative instruction. Again, in order to preserve the issue for a trial court's review of a motion for new trial. And if it's not preserved in this manner, then the conduct is subject to a fundamental error analysis. And that's under the very classic opinion of Murphy versus International Robotic Systems, Inc., 766 Southern 2nd, 1010, Florida 2000. Everybody knows about that case. And there'll be several cases afterwards, but that's still the fundamental law governing improper argument. So you want to try to follow procedure so you're not going to be stuck with a fundamental error analysis. But if you have to fall under that, then the court engages in an analysis, and that's what Murphy talked about. So when you're analyzing fundamental error, the party moving for a new trial must first establish that the argument being challenged is, in fact, improper, of course, right? The party must then establish that the argument is harmful, which requires that, quote, the comments be so highly prejudicial and of such collective impact as to gravely impair a fair consideration and determination of the case by the jury. So that's the test. And then third, the improper comment must be incurable, meaning that sustaining a timely objection and providing a curative instruction to the jury could not have eliminated the probability that the unobjected to argument resulted in an improper verdict. And then finally, under Murphy, the party must establish that the argument so damaged the fairness of the trial that the public's interest in our system of justice requires a new trial. And then the courts interpret this category as being very narrow in scope. And for example, appeals, quote, appeals to racial, ethnic, or religious prejudices. So once a party has demonstrated all four requirements, that party is entitled to a new trial on the basis of fundamental error. And on appeal of the trial court's decision to grant or deny a new trial, the appellate court applies an abuse of discretion standard of review. So try to follow the procedure. As you can see, the fundamental error analysis subject to a subjective analysis. So follow the procedure, and I think you improve your chances of getting the relief that you're looking for on appeal. Now, also realize that review of any objection made during closing argument is limited to the grounds that are stated in the objection. So you can't just stand up and say, that's not right. That's a lie. I don't agree with that. No, you have to be very specific in your objections, and that's what the appellate court will look at. And it's really utterly amazing, you know, opening and in closing statements, what people get away with. And it all depends on the judge you have, and you know how much leniency, how much room that they're going to give. So just be watchful, and you're going to only, is it strategy? You don't want to object so much that you're getting the jury upset at you, but it's got to be pretty egregious for you to get up and make these objections, of course, and move for a mistrial. And I believe we've hit all the juries, so I think the final landmine, we'll call it landmine number 10, the motion for new trial. So a few things you need to know about this procedure. So a motion for new trial and the order entered on it is a prerequisite to challenging the sufficiency, in other words, the manifest weight of the evidence on appeal, okay? And the same rule, same requirement exists if you're going to challenge the inadequacy or the excessiveness of the jury verdict. So merely alleging in your motion for new trial that the verdict is contrary to the manifest weight of the evidence will not be sufficient to preserve for appellate review inadequacy or excessiveness of the damages. So a motion for new trial is not required to review issues unrelated to the sufficiency of the evidence, such as rulings on evidence and the jury instructions. So those are examples. So that, and we've had a lot of cases, and we'll make sure that they're up on our website and on the journal. Lots of landmines, but these I feel are some fundamental ones that I've seen through many years that can, if it's not done right, it can get you and your client in a pretty sticky situation. So I recommend you stay on top of this. And again, thank you for joining us this week. Again, if you have any issues that you'd like the journal for us to visit over the next few weeks, few months, by all means, just let us know. Thank you again. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.